It's really a pleasure to have you join us on this Let's Talk Justice series, Moffett. And you are an expert in reparations. You've done a significant amount of work on reparations in relation to the cases before the International Criminal Court, but also more broadly. We've had a chance, and I will share that for those persons who are listening in, some of your work in relation to reparations in Nepal, Colombia, Uganda. The list is very long. So great to have you join us.
Yeah, thank you, Lorraine, for having me. I'm looking forward to our conversation.
So I just wanted to have a chance to talk a little bit about reparations at the ICC context. It hasn't gone, I think, the way that a lot of people expected it to have gone. The expectations were that, you have a court set up, which is very different from the ad hoc tribunals in terms of having a built-in provision for reparations. But so far, we've seen reparations orders in 3 cases. And the case that I wanted us to focus on today, the case of Bosco Ntaganda, there was a conviction recently, but it's on appeal. But the judges have actually, at the trial phase, have gone ahead to issue a decision on the reparations process, a first decision on the reparations process. I wanted to get your thoughts on that. What do you think about the judges in Ntaganda deciding to issue a decision at this stage of the proceedings, given what happened in the case of Jean-Pierre Bemba?
Yeah, that's a good question. I think that the court's process on reparation continues to evolve, and we'll talk about Ntaganda in a second, but if we look at the broad context of the countries that the ICC is working in, so Northeast Congo in Ituri, and then Mali, where the Al Makti case was, these are still areas of ongoing conflict, and the Ntaganda case, as it's still in Ituri, still faces ongoing violence. So it's very different from other reparations processes, such as in Nepal, well, to a certain extent, Colombia, Peru, and others, in the sense that those countries have had a peace agreement, or there's been some sort of settlement with the conflict, so the conflict isn't as prevalent. The second thing is with the ICC, and that's unique, is that it's a court-based process, and reparations, as you well know, is sort of tacked on at the end. It's sort of an afterthought of the trial, but the trial defines and frames everything that follows for reparations. So this is very clear with the Bemba case, where he was convicted and then later acquitted. And during that sort of 2-year period between those 2 decisions, you had experts out in the fields interviewing victims, the court engaging different actors on what reparations would look like. And we were expecting a reparations decision before that appeals judgment, but the decision sort of just killed it off, and victims were left very, very frustrated. And it's a difficult process, but it also affects the strange formulation of reparations within the court, in that reparations almost have to rise to a criminal standard, in that victims are recognised for the trial to a certain extent, but to benefit from reparations, it has to be against a convicted person. And as we all know, international crimes aren't committed by one person, it's a whole group of individuals. And the Ntaganda case is quite interesting in that respect, because it's intimately connected to the Lubanga case,
Yes.
because of the same group. And he was convicted of child soldiers. Ntaganda has also been convicted of child soldiers. But there's also the broader context that Bosco Ntaganda, Thomas Lubanga also had other individuals they collaborated with, other organisations, and even other states. And so, related to this case in Ntaganda and Lubanga, you've got the International Court of Justice decision of the DRC v Uganda about the armed activities and the effective annexation by Uganda of Ituri in the early 2000s. So it's quite a complex area to start doing reparations in. So the Ntaganda case is interesting in the sense that it's a difficult context, but it's also probably the court's most complex decision so far because of the range of crimes involved. Lubanga was only convicted of 1 count of using and conscripting child soldiers. Ntaganda faces 13 charges.
Yes.
Or has been convicted of those. one including child soldiers, the rest including sexual violence, forced displacement, killings, across a 16-month period. So it's a far bigger case. It's far more complex, stuff that the ICC has never done before. And so this decision that the court has made in the last couple of weeks is trying to start that process. Yet we're a year on from the original conviction of Bosco Ntaganda, and we're 18 years on from the actual crimes. Like, reparations always come late. They're never done quickly, and in times of conflict, it often sometimes has to wait until the cessation of violence. But this is just incredibly slow. And so I think it's good that the court's making a decision, but I think it's also got some trepidation around moving forward, given the experience of Bemba, where victims had expectations raised and then dashed by the court when he was then acquitted.
Mm-hmm. I mean, you've really highlighted a number of issues there, Luke, and I think it's important to unpack some of them. And just for our listeners who may not be as familiar with the case, but for example, one issue you highlighted was the intersect between the Ntaganda case and Lubanga, and how that also serves as a complicating factor. And it would be good to hear from you in a little bit more detail about why that is such a complex issue, given that, Lubanga was convicted several years ago. Well, not so long, but he was before the court for several years before Ntaganda faced the ICC. And now you have victims who are potentially eligible for reparations under the Lubanga framework or in the Lubanga case, but may also be victims in the Ntaganda case. How do you see, and I know the judges dealt with it a little bit in their decision, how do you see the court approaching that, or how do you think that particular issue should be approached?
Yeah, it's definitely going to be a difficult issue. I suppose if you had a Venn diagram in terms of the Lubanga case and Ntaganda, it might be like, sort of overlapping and only a small area in between where there's maybe potential for something new. And what I mean by that is Lubanga, the reparations decision was, 2012, 8 years ago, yeah. And sexual violence wasn't included. And so Bosco Ntaganda is really making inroads around ensuring that victims of sexual violence, including sexual slavery of child soldiers, is included. Now, the difficulty is that you've already got these same victims who are eligible for collective and symbolic measures under the Lubanga decision, also then participating in Ntaganda, but also suffer sexual violence, that aspect which was left out in Lubanga. Now, I think that this offers the court to sort of revisit the Lubanga decision on reparations, given that a lot of it hasn't been implemented. There's been difficulties in procurement. There's been difficulties of rolling out these measures on the ground. And from working with victims, including a lot of child soldiers in Nepal, Colombia, and other places, there's always going to be tension in reparations, particularly with those who are not purely innocent victims. And I'm not trying to say what child soldiers did to them was wrong, but they're also responsible for victimizing others. And so part of the court's initial decision, which was sort of stripped back in the appeals decision, was the concern of community tensions, that the court didn't want to upset the way in which these child soldiers, who some people saw as victims, who were coming from a certain community, would be seen as benefiting from the court when their own victims, these child soldiers, the people that they had victimized, wouldn't be eligible. So the court didn't want to raise those sort of tensions, and so avoided doing individual compensation. Now, the Ntaganda case changed that, but we're not talking about big money. I think working in other cases involving victims, money gives victims the means to choose what they want and how they spend it. So it's about agency. It allows them to save or to pay off debts or pay for healthcare or just give their children to ensure they can go to education for a few years. We're not talking about big money. In Ntaganda, it was $250. When we were the amicus in that case, we recommended $500 because that was the value of a cow at the time. But I think it's about giving some sort of reparations that means and has value to victims to spend as how they see fit. I think there's a concern at the ICC, and Phil Clark's work is quite good in terms of distance, that it's so far removed from these contexts that it's almost come quite paternalistic. And it's a very different reparations process from if you look at others in countries like Colombia and Chile, any sort of context which has a reparations program, in the sense that it's very top down. There's very little ownership or sustainability and involvement of victims' organisations to shape the reparations debates within the courts. Yes, victims do have legal representatives, but the way in which those issues and interests are understood is within a criminal court lens. And also then reparations are very legalistic. There's very little space to negotiate and engage with those responsible. There was a little bit of that in Katanga around apologies, but it wasn't. Well, it's so far removed, and that's what Phil Clark's whole take on the ICC is. It's beyond just the physical distance between the Turi context and The Hague, to also reflect, what's going on to the ground. And we see this in Turi, where there continues to be violence, there continues to be stigma, and it's sort of like everyday social interactions that the ICC is very far removed from a lot of people's minds. But reparations at least can provide some sort of individual acknowledgement and some measures to alleviate that harm. Now, we're not saying what the ICC can do is full reparations to return the victim back to the state they were before. It can't. No reparations process can. But what it can do is provide measures that recognise they suffered harm and try to shape it to what they need. And victims in the Lubanga case were child soldiers, but it didn't really address their needs of, suffering sexual violence, suffering loss of opportunities, and ensuring that they had some sort of agency in that. And this is the thing, that in the Katanga case and even the El Makti case, victims, when they do get these collective measures, and even sometimes when it's certain funding used towards housing, they can't use it, they don't want to use it because of the insecurity. They're worried that the violations are going to happen again. And this is the sort of one of the long-term downfalls of reparations at the ICC, compared to maybe other contexts, is that it can't guarantee the non-repetition of violence, because the ICC isn't responsible for the violence. It's the state and local actors who have to be responsible for making reparations, but also preventing it from happening again. And sometimes we often forget when we're talking about these subjects.
That's a really important point about guarantees of non-recurrence and the ICC's role in what I call the broader transitional justice picture, the broader framework of justice, because increasingly, and we've seen a recent report by the International Federation for Human Rights and the Kenyan Human Rights Commission talking to different victims in situation countries, in ICC situation countries, and the verdict ultimately is what you've just said, this sense increasingly of a distance between the ICC and the population that is intended to serve. And I wonder whether this is now even more exacerbated by the fact that we are in the middle of a global pandemic. It would be interesting to hear your take on this, because in the decision, the judges asked the Trust Fund for Victims and the Victims Participation and Reparations section to address that issue specifically. How would they, for example, be able to identify potential beneficiaries given the lockdown in the Congo, given the restrictions on travel in Congo and from outside? And it would be interesting to hear your thoughts on how this pandemic presents even more of a challenge for the ICC in relation to actually bringing, its reparations goals to life.
Yeah, that's a good question. I think there's one issue that maybe the Ntaganda case is very different from the others, is that during the trial process, and this has always been a concern in the ICC, is how to collect data on victims. And so increasingly, they went from a 17-page application form to a 7-page one, it's like a 1 or 2 page. And so we're collecting fewer and fewer details of victims' personal circumstances and harm. I just wonder the extent in which the ICC actually has any knowledge of the victims' community in terms of the harm in order to inform reparations, because that would be the first place that you would look. Not all those victims perhaps have all the evidence to support that, but having that sort of database of harm would give you a starting point to sort of map out the victim universe, but also the nature of harm which they're suffering. And I think given that COVID is now happening, it's going to be very difficult for the victims to come forward, because they don't want to risk a transmission, or because I know in colleagues in Uganda and victims there, they face lockdown and they're not able to come out and to sell their produce, so they're lacking the means to economically support themselves. So why would they engage with a court or an international body when it risks, putting their livelihoods in danger, or the ability to sustain themselves, or even just exposing themselves to health? I know even in Northern Ireland, a number of victims here who are left seriously injured have almost, been unable to physically demand their rights to reparation because they have underlying health conditions, and that means that they have to self-isolate. So it's almost, having the pandemic is a clear physical barrier for victims accessing and advocating for their rights. And in the case of Northern Ireland, it's allowed political parties to deny victims their rights to reparations, despite already having a law in place. And so I think when it comes to the ICC, it should be very attuned, not just to the conflict context, but also the pandemic. And I know that the court has appointed 4 experts, but how will they travel out? If they do travel, I think the DRC has still a quarantine in place, so they might have to be there for 2 weeks and unable to speak to victims. Also for victims themselves, like the risk of transmission from movement to different areas. And a bigger issue is that how does the court engage with victims in sort of gathering their views and perspectives? Now, one way that the VPRS and the victims' lawyers are probably already in touch with victims through intermediaries or mobile phones or WhatsApp or whatever way they communicate. So there might be, to a certain extent, a technology solution to some of this. But I always think that these sort of issues, technology only gets us so far. Like even us like speaking now, it's better when we're in person. We can chat. And,
exactly.
It's a bit more fluid, and you can get social cues. And I think also for the experts, it's about taking in this sort of environment and context. That if they have to do everything digitally, or they can only do things at a very arm's length distance, it's almost like a human connection. And I think this is a problem of a legal approach and even a court's approach to reparations, that we're talking about people suffering. And Trudy Govier puts it quite nicely when she talks that reparations are doing something quite impossible, because we're trying to quantify harm, we're trying to put a number on it, and yet this is subjective, this is qualitative, this is something very personal, and we're reducing suffering down to something which can be bureaucratized and paid for. And I think that the ICC thinks that with reparations, we go through this process, it's very technocratic, we get experts to say this is what we should do, and they'll probably come up with something really innovative. We're trying to get donors to give some money, and then we can tick that off. And I don't think reparations aren't about that. It's about trying to acknowledge victims suffered harm. It's in getting the responsible parties involved in owning up to the past, but also trying to prevent it. And then getting longer term support, because we're talking about victims who suffered sexual violence, victims who've had family members killed, who are completely left destitute, suffering health problems. This isn't going to be solved with $250, $500, giving them a car, giving them a home. It doesn't work like that. We've done extensive research in other countries, and those sort of collective measures are one-offs. Victims then don't get second chances if the environment changes, if the conflict comes back again. So we're not really improving victim situation. And I just wonder, who does this process serve? Is it about putting a good face on the work of the court, saying we're helping victims? Or does it involve a restructuring of how we look at the ICC and start getting states more heavily involved?
Mm-hmm. As I said, it's one of these issues that you feel like you're a little bit in a catch-22 situation, because we know, those of us who have worked on these issues know the gaps that we see in a lot of the national reparations programs. We've seen in some countries, and we can use Uganda as an example, where debate on a transitional justice policy which includes a reparations framework, has been debated for 10 years. So we are aware that at the national level, there are huge gaps in terms of remedying the suffering of victims. At the same time, I fully agree with you that the sort of bureaucratic approach to reparations doesn't serve the victims either. And I think we became all aware of the limitations of what I call the international justice approach to, or the conviction-based approach to reparations in the Bemba case. And I wonder whether you could speak a little bit to how that could play out now and in the Ntaganda case, given the significant risk that I think the judges are taking by going ahead, you know, to set things up procedurally. Although I must say, I am a fan of trying to do as much as possible procedurally to put things in place, because it has just taken such a long time to get things going once there is a formal reparations, once there's a formal decision made afterwards. So I don't know if you wanted to quickly share your thoughts on this. I know we don't have that much time, but it would be great to hear that.
Yeah, no, I think that's a really good point. I think the conviction-based approach puts all our eggs in one basket. And these issues aren't new. You know, the ICTY and the ICCR judges wrote a letter to the Security Council in 2000 highlighting all these things, that we need to have sort of a claims commission or some sort of administrative body, because a court-based approach doesn't work. And we haven't learned from that, and we haven't improved, but just sort of, you know, headed on and just try to deliver it. I think, you know, the Uganda case is a good example, and I'm hopeful that Ntaganda and what the experts promote will set a new example of how to do reparations at the ICC. We'll hopefully get some sort of, you know, reparative complementarity going on with the Congolese government. But if Ogwin is convicted in the Ugandan situation, I think it'll be a good benchmark of how to build a comprehensive reparations program. But as you're right, we need to tie it in with what the Ugandan government's proposing under its transitional justice policy, how these things can work together and be more sustainable.
Yeah.
My concern is that with a lot of reparations is that we're just trying to buy off victims and silence them. And that it's, we say, job done, move on, and victims' situation doesn't that much improve. That we use victims and invoke them so much for the justification for international justice, and we spend tens or hundreds of millions every year at that. Sadly end up in the pockets of lawyers or institutions, and that the victims who have suffered these crimes continue to struggle on. And I know, and I agree that, you know, as a lawyer, we have to be careful that, you know, we're talking about an individual who's being convicted, and, you know, Bemba's assets were left to rot effectively, and so it does have implications for them. So we can't just be blithe and, you know, who are pinning the cost of reparations on. So that's why it's important to have a fair trial process and to allow the appeals to take their course. But these victims waiting so long, I think something we've been talking about for the last couple of years, I think we talked about it in The Hague in October in 2018, was about this issue of trying to do reparations more quickly, to reconfigure the trust funds mandate, instead of doing assistance for all victims in a situation and, you know, playing like a local NGO and just, you know, giving money to those groups. Instead, we should talk about interim relief. That victims who come before the court who have serious injuries and disabilities or vulnerabilities should have priority access to some sort of support, whether it's healthcare and psychological support, or even some sort of basic finance to pay off debts or allow their children to go to school. It doesn't interfere with the individual who's been on trial, because it doesn't recognize that that person is responsible for it. It's recognizing that these people are individuals who are suffered as victims, that objectively they have suffered a clear harm. And I think we should be thinking about that, being more reflexive and proactive in helping victims. Because the sad truth is, in Bemba, the victims who had suffered sexual violence, as we spelled out in our amicus to the court, had died. You know, if you've suffered serious sexual violence as they had, they're not going to be living now. And it's similar concerns for other victims, as you well know, in Uganda, who are continuing to live with consequences, such as children born of war, who can't get, you know, proper citizenship status, and people who have lost family members and their bodies have never been recovered, and they can't do the proper ceremonies in order to sort of consecrate their death. So I think the ICC is space for innovation, but the ICC is a tiny little part in redressing the past, and we have to be modest in what it can do and honest. That's really, the states need to get involved, those responsible. And I think with the Ituri situation, and even in Northern Uganda, there's an absence of the state, or the state is only there to instrumentalize its own economic objectives or its own kleptocracy, you know, where it's trying to ensure that those elites maintain their money and power, and it doesn't really help those marginalized. And these are bigger structural issues that the ICC and perhaps even transitional justice can deal with.
Yeah. And, you know, I just want to pick up I think as our last point, but definitely by no means the least, and that's what you mentioned about the prioritization of victimization. I wonder whether, given that, Ntaganda is now being held up as, the case. Of course, we have the Al Hassan case, which just started, but the conviction for sexual slavery, including, for persons who were within Ntaganda's troops itself. I think for a lot of people, sets a message, or that the ICC needs to be very clear about reparations for victims of sexual and gender-based violence. It would be interesting to hear how you see this, how you see, reparations, the sort of the gendered dimension of reparations in the Ntaganda case, whether you think this is something that the judges need to prioritize, whether you think they need to put something special in place, or focus primarily on the SGBV victims.
Yeah, no, that's a really important point. And the Ntaganda case, there's still a lot of struggle, to get things done, but it has achieved a lot. It's the first conviction for sexual slavery at the ICC. That said, there's a great book just published by Carson Stan, is Justice as a Message. It's about how law speaks and how it conveys messages. But does anybody on the ground listen? Mariana Getz wrote a really good chapter in her book with Carla Firstman recently about the sort of social mistrust on the ground. There's mistrust of the ICC, and the convictions aren't having that sort of impact. And I know Diana Ornlichter and others have published on the long-term impact of the ICTY. And even when you have these trials, it sometimes doesn't change things on the ground. So like having an individual prosecuted for sexual slavery doesn't always change the sort of cultural understanding of these violations as crimes, or sees them as permissible, or even that those individuals who committed those crimes are seen as heroes, and their crimes are denied or justified as necessary as part of war. So I think that the gender dimension messages and gender-based violence that the ICC can send are probably going to be quite limited, because they're being broadcast from The Hague, and I think there's maybe not that respective audiences on the ground. Even in like Western countries where we still have like issues around Me Too, we've still got historical institutional abuse, that when it happens in the margins, we don't really care, because it's not happening to us. And for too long that's happened on gender and racial grounds. But I also think that when it comes to the ICC, what's the value added? I think it's good that it highlights these sort of big crimes, but it can't just be sensationalizing. And that's what happened in Lubanga. It was about child soldiers. It was a case for child soldiers. Bemba was a case in sexual violence, and we saw how that fell apart. So I think there needs to be more systemic engagement with state parties. The state parties have signed up to this, to look at themselves very harshly. The state can't do it all. We need also civil society. We need communities to sort of engage with how sexual violence happens. And I think with the ICC, we sort of prioritize the sort of conflict-related sexual violence, and we don't look at the sort of intimate partner violence. We don't look at sort of how sexual violence or even just gender discrimination works more broadly. So I think that it's a very difficult subject, but it needs to be engaged with. It needs to be grappled with. In order to prevent it from happening again. And if you want to end impunity, it can't just stop with international crimes, these big headline crimes.
Yeah. And I think the one last thing I want to pick up is what you mentioned about the role of states in this. Because we know, for example, the trust fund is the vehicle through which reparations is administered at the ICC. And the structure that the trust fund has is very, in terms of, funding, is very dependent on donor support from states. It was actually set up by the Assembly of States Parties. So I wonder what you see as almost a forecast going forward, given the limitations that we've had, that we've seen with the trust fund so far in getting funding, given that every single accused at the ICC so far is deemed indigent, which means that the trust fund basically has to I would say, offset then or upfront the reparations awards. But in this COVID era, where states are looking more internally, how do you see that playing out in terms of the level of support that the trust fund will get? And what do you think the trust fund needs to do to innovate in order to really meet the demands of its mandate?
Yeah, that's a difficult but a good question. I think, it was a couple of ASPs ago that some individuals try to propose that states invest in a bond, so like a $1 billion bond, and it'd be 40 million that could be paid out every year. So trying to make reparations a bit more sustainable. My concern is that trust funds never work when it comes to reparations, because it's effectively, it's almost like treating victims, and many victims have said this, like beggars, that they have to go around begging for a bit of charity. And really, reparations are a right. It's a human right, and the state is responsible for that, whether it's by its own actions or by private actors in failing to protect citizens and those within its territory. So I think that when it comes to building sustainability for the trust fund, I don't ever think it will get beyond what its current income is, about €4 to €5 million per year, and reparations are going to outstrip that, I would say, in the next 5 to 10 years, multifold, because you've got big complex cases where thousands of victims are participating in each one. And so really it has to involve the state. And the reason why we are in this situation is because, the Rome conference 22 years ago today balked at the idea of the state being responsible for international crimes. And that was one of the key debates. And so we've got this sort of provision, which is a fudge, that it's dependent on individuals contributing to reparations. And it doesn't work anywhere else in the world. Usually the state has to do it, because the state has the finances, has the capital and infrastructure to implement it. And reparations, yes, can be a financial commitment, but they don't have to be, devastating for a financial economy if they're planned right. So I think we need to sort of shift the debates, that the trust fund says and does that all these things, but really it's just a bank account that sort of allocates money to different groups. So I don't want to overstate, what it does, and I'll probably be hated for that. But I think that, the way in which we think of things, like, it's just like magical. It's like, oh, the ICC prosecutes crimes, but get justice for victims, and then victims' harms will be remedied in reparations. Reparations are really messy. They're contested, and I think it's no panacea. It's a band-aid for deep wounds that are left in society, and it can't simply be solved by the ICC. I'm not saying the ICC shouldn't be doing it, but we need to bring on other actors and give better ownership to states, to other responsible actors, including multinational corporations, local armed groups on the ground, to ensure that these crimes don't happen again, but also that they confront what they did. And a trial is supposed to do that, but you're doing it against one individual. And so I just don't know. I think it's interesting at the moment. Lubanga and Gatanga have been released and then recruited to be peace builders in Ituri by the Congolese president. So it's fragile. So there's, countries moving away from conflict, that the past never really is past. It continues to create for the present, and until it's dealt with, until like the economic social consequences are confronted and like properly addressed, it's going to continue. And I know that in Ireland, there's been 800 years of transitional justice that has sort of bought off some people, given rights to others, and never really changed fundamentally the sort of ingrained social and cultural reasons for hating and fighting against each other. And there's many countries around the world like that. And so the courts, when we look at it, maybe in 50 years' time, we can maybe draw longer conclusions. But even in Germany after the Second World War, struggled with doing reparations, because through denazification and the reintroduction of pensions for Nazi officials, you had more money being paid out to Nazi war criminals and members of the German army than there were to victims at the time. So it's incredibly complex and complicated. You even had Nazi judges and doctors denying reparations to victims. So no country is perfect in doing reparations, but we have to deal with it some way. Otherwise, the burden of the past too heavily rests on the shoulders of victims.
Yeah, and I think that's a good place to wrap up this talk. And I think we'll just have to keep watching to see what happens in Ntaganda. But I fully agree with you that it is a complex exercise. It is complex, and we are just really, really at the very beginning of things. The pace at which it has moved at the ICC so far has been painfully slow. So I don't expect that the Ntaganda case will be any different. But I fully agree that we need to look at this through different lenses. We need to begin to have a more inclusive approach to reparations, that states are included in the process, the armed rebel groups who are also responsible, that all of the relevant stakeholders begin to look at this and take some of the burden off of the shoulders of victims. Because otherwise, we'll be having great discussions about this forever and nothing actually getting to them on the ground. Luke, thank you so much for taking the time. Really interesting. This is something, we could always talk about and we could keep talking about, but it's been great. Thanks a lot.
Thank you, Dara.
Okay.